12:30.
Yep. Good morning, everyone, and welcome to the Committee for Communities meeting on Tuesday, the 21st of December, here in Room 30, Parliament Buildings, and I'm declaring the meeting open to the public. Members, will just confirm who we have in the room and who's attending via Starleaf. There's myself, Kelly Armstrong, Paul Frew and Andy Allen in the room, and on Starleaf we have Aisling Riley, Anya Murphy, and I see Ciara Ferguson, but I think it's below the list that I can see. Is there anyone else on that list? Oh, okay. Thank you very much. Just to remind members of the requirement to declare any interest they may have in relation to items under discussion today.
I'm a second landlord, Chair.
No problem.
Owner of a rented property.
Thank you. And anyone know of any apologies? I'm aware Paul Bradley, our chair, and Steve Dunn are having apologies today. Anybody else? Mark Durkin will join us later. Members, the draft minutes from the meeting on the 14th of December 2021 are on page 5 of your pack. Members, are you content to agree the minutes of the 14th of December as drafted?
Yep.
Yep, thank you. I'll get those signed. And then agenda item 3 is committee deliberations on the private tenancies bill. Members, the committee will now continue its deliberations on the private tenancies bill. This is still not the formal clause-by-clause stage. We are still reviewing responses with the department on a number of the clauses to agree amendments and decide on whether any further amendments are to be considered or whether a committee recommendation or ministerial assurance would suffice. Members, you've been provided at page 24 with a response from the Housing Rights in relation to Scottish research on rent increases relevant to clause 7 of the bill. Members, have you any comments or are you content to note? So it's on page 24. Are you content to note? All quiet?
Yeah, Chair.
Yes, thank you. Okay. Members, a copy of the bill is at page 25. The 2006 order is at page 65 and the evidence summary tables start at page 120. Previous departmental replies to committee queries start at page 222, all the ducks, so 222, and the most recent response to the letter we sent after our meeting on the 16th of December is in your tabled papers. David Polley, Eilish O'Neill and Karen Barr from the department are in attendance. Claire McCanny from the Bills office is following proceedings and will be available to the committee for a closed session at the end of this session, should members need that time with the bill clerk to discuss options for amendments and instruction for drafting committee amendments. Are members in agreement to proceed? Yep, thank you. Members, questions or comments should be focused on the specific clause under discussion. If members are content, we will then make a start and welcome to the meeting David Polley, Eilish O'Neill and Karen Barr.
Good morning, Chair.
Good morning all. Members, we'll start at clause 3, tenant to be provided with a rent receipt for payment in cash, and we have 3 matters to consider. Firstly, receipts for all cash payments in relation to the tenancy. At the meeting on the 16th of December, the officials advised the committee that the Minister will take an amendment to the clause or insertion of a sub-clause for a receipt to be provided for all cash payments arising under the tenancy. The committee was pleased to note that the department was making this amendment. Members, the text of this amendment has been received and is in your tabled papers at page 7. Members, this text actually comprises 12 separate amendments. Some are technical and consequential, but I request, please David, that you take us through them, even if it's just to say it's technical and consequential. Each point of insertion in the bill represents a new amendment, and it's important we are clear about the purpose of each. I'll maybe run through them all and then we'll come back. David, if that's okay. Well, maybe we'll take this one now. Maybe that would be the easiest way to go. Yeah. So, David, if we'll look at that one, then it's the amendment that we have with the 12 separate amendments. So, if you could go through those and just let us know, technical or consequential. Thank you.
The committee asked us to prepare an amendment to this,
Oh, we're very quiet. Sorry, David.
Your volumes.
There we go.
There we are. Thank you.
It's a problem with user, not software. Isn't that what it's? So the committee asked us to look in to do an amendment on this, and as you can see, we've gone through the whole clause, and there's a few bits that we'll want to pick up to say that we spotted an issue and we've tried to resolve it in the legislation. So Karen's going to go through each of the separate bits of it with you now.
Okay, thank you.
Okay, so starting at the first one then, clause 3, page 3, line 7. This is really bringing in the new policy intent. We're going to now cover receipts for all payments and no longer just rental payments. So the important words are any at the top of clause at the first part there. You'll see any payment and any payment in satisfaction. That's including other payments now. In amendment in 5.2a, in 2, first of all, we've included what the payment was for. We're used to just, because it was only rent, we didn't need that, so that's been inserted into 2. In 2a, this is to provide where a lump sum is given for different payments, that there is a need to show how they're apportioned. So if it's so much for rent, so much for repairs or whatever, and that each amount is whether it's paid in full or if there's still some outstanding. And then 2b is to explain where the landlord isn't maybe clear so say there's repairs and he's said it'll cost so much, and then when the work's finally done it's more, that he's given the best of his knowledge and belief, he's given the amounts that are on the actual receipt. So that's to cover that scenario. Are you happy enough that explains? Or
Chair, that might be a good place to pause, because that one amendment does cover off most of the policy intent that we've been trying to draw in from our discussion with the committee about what we're trying to change in this clause. So the receipt will now have to say what the money's for. We've covered off that it would need to be apportioned if there's for how many things, how much is outstanding for each one, and then, as Karen said, because it's quite likely in some scenarios that the landlord might not actually know exactly how much is outstanding, we had to consider whether or not we discounted those bits of the requirement for non-rent, but we decided to leave them in, but put this thing in saying that they had to say to the best of their ability how much was outstanding.
Okay. Members, any comments?
Yeah, if I can come in, Chair. Yeah, I see what you're doing there, and it's thorough. So I commend you for that. I think you've picked up all the pieces that we would have concerned about, and of course the whole principle around this amendment is about catching that other payment other than rent, and that being in cash, which is still a big issue for me. So whilst I've only had a 24 hours or whatever or a wee bit longer to look at this, I seem to be supportive.
Okay.
Yeah, can't believe I've just said that at this stage, but
we'll take that. Okay, so that's the first one. The second one then, clause 3, page 3, line 21. It's just a technical amendment or drafting amendment even to use more appropriate language. That was just the drafter, and he changed the way the words are, and not simply for a drafting amendment. He felt it was more appropriate language, so it's not changing anything really at all. The next one, clause 3, page 3, line 26, as a consequential amendment, as now what we were just talking about, as now we're going to include payments before a tenancy that are linked to the tenancy, in that maybe deposits, rent in advance. So it's making it clear that payments are included before and after a tenancy ends. So that's really that one.
So we wanted to put on the face of the bill what you said, just that it's every cash payment in relation to the tenancy, but those relation to the tenancy can't therefore be defined as a day between the day it starts and the day it ends. It includes between a landlord and a tenant afterwards. and a landlord tenant before. So we've made that clear.
Okay. Any comments,
Okay.
anyone? Yeah. I think that's, yeah, we're getting agreement here, David. Thank you.
Okay.
Okay, then clause 3, page 3, line 29. Again, this is another technical amendment, and it's drawn attention to the landlord as the person committing the offence and the person responsible. I think there's actually a couple of these in a row here. Clause 3, page 3, line 32. Again, as previous, drawn attention to the landlord, but this time for a continued failure. So,
Sorry, can I ask, with regards to inserting A, what is A? Is A the further up in the new amendment?
the A, whenever you go down, is what the landlord, David, isn't it now? A's down,
Yeah,
because the
so-
landlord includes former and prospective.
It's the new, no, hang on. It's the new 5.5a.
Yes.
So the one above, if the landlord of private tenancy fails to comply the following are guilty of an offence, the landlord and their agent, the person appointed by the landlord to provide the receipt. This is drawing attention to the fact that in this instance, it's actually the landlord.
Yeah.
Yeah,
And that is, that's actually the situation because of, Karen, keep me right here, the law of agency. So if you appoint somebody to work on your behalf, that is the legal position anyway.
Yes.
But the drafter wanted to make it abundantly clear on the face of
Yeah.
the bill that responsibility lies with the landlord.
when it
and
comes
they
to
can't,
criminal offences, yeah.
yeah, and they can't say, oh no, it wasn't my fault, the agent didn't do it.
Yeah, okay, got you there. Yep.
Okay, now which one was that? I'm lost now. So that was
There's
line
three of those.
32?
Yes.
Yeah, and then again, clause 3, page 3, line 36, and that's where it talks about the fixed penalty notices. And again, the references to 5ZA to a landlord being convicted of an offence under what's the new article must be it relates to it being an offence to him personally. So that's what that one. Then clause 3, page 3, line 41 is a technical amendment.
Sorry, so just before you go off the A's, if
Okay.
you so that I don't lose this, and so you guys have a better chance to answer it. So are we saying then that 5B, any person appointed by the landlord to provide the receipt, is now removed?
No, I think in the first instance, you can charge both. If I'm reading this properly, there's I don't have the other thing in front of me at the minute. So I think in the first instance, David, it is the way it was before, where it said the landlord under the tenancy and any person appointed can be charged in the first instance. That hasn't changed as far as I know in the new version.
No, I don't think that's changed.
No, it hasn't. It hasn't
It's-
changed.
Yeah, it's just whenever it comes to criminal, so it would be the continued failure then. And the continued failure is where the landlord only would be charged.
Right. I'm just wondering how that plays consistently then, because you have 5B, which is so if I read 5 in its in its completeness, if the landlord under the private tenancy fails to comply with paragraph 2 or 3, the following are guilty of an offence under this order: A, the landlord, and B,
Yep.
any person appointed by the landlord to provide the receipt.
Yeah,
Yeah.
So by adding those A's into clause 3, line 29, 32 and 36, are we putting more weight then or more burden on the landlord as opposed to the person appointed?
Yeah, so this next bit, 5ZA, the whole next bit, it refers to the continued offence.
Yeah, it's a
Karen
continued
said.
offence.
So that's, if you keep on doing it, once you've already been convicted once.
Right, okay.
So at that point, we're making clear. Now, that is how it's originally drafted. If you look at that bit, it says if the landlord, but then what we're doing by adding those A's is we're making it abundantly clear that the continuing offence is the
Yeah.
landlord.
Got
But
you now.
that is the original way it was drafted. It's just trying to clarify it.
Yeah, so all those A's are going into 5ZA.
5ZA,
Yeah.
yes.
Yes,
Yeah.
okay. Got you now. Thank you.
Okay.
Okay.
okay, let me see where we were. So we're on clause 3, page 3, line 41.
Yep.
Again, this is a technical amendment added. It's referencing an offence to which the the defence in question operates, and it's just making it clear, as the adding of new material into the whole article means it's helpful to add a link back to the offences mentioned in the new para. And I'm not sure if that's clear or not. David, I don't know if you want to...
I hang on a minute. I think we're maybe getting a bit mixed up. So this is clause 3, page 3, line 41, at end insert. In this article, landlord has a meaning given by Article 5.6. Article 5.6 is the new 5.6, which includes the material on prospective and former. Okay. Former landlord and prospective landlord.
Yeah.
Okay.
Yeah. So this is clarifying. This is clarifying that the continuing offence also applies to prospective and former landlords.
Yeah.
Yeah.
Happy with that one then?
Yeah, and again, I think that's important because of the nature of a relationship. You could technically be a former landlord or a prospective one, but yet still cause harm to tenant,
Yeah.
so or prospective tenant.
Yeah.
Or
well, we thought there were quite a lot of cash payments before. Yeah. I mean, rental advice and advance and deposits.
Yes. You
mentioned deposits, okay, but also at the end of it, because it's not. It is possible there could be damages in excess of the deposit amount,
yeah,
and a cash payment be made for those. So it was conceivable there was some there as well.
Yeah.
Yeah.
Okay,
so we're now on 5ZB.
Okay, and is this clause 3, page 4, line 4? Yeah. Where do we see? Oh, we are here.
Yep.
Yeah. So this 5ZB only applies to rent payments. Now it's because it's a defence in a very particular set of controlled tenancies, where the rent officer has determined a rent. So it only refers and applies to rent payments, not the other payments. There is a defence there where a rent officer may have determined a rent and the landlord may have felt that the new rent came into place. So it's very specific to the controlled tenancies.
Yeah.
Is that because what we've done here then is this bit, the point of this bit is not to add something in, it's to make clear that the new thing doesn't apply to this, because this is a defence.
Yeah.
For you, a reason why a very particular set of circumstances the landlord might not actually know how much rent is due and might not be able to give a correct rent receipt. But we thought that this didn't apply to anything other than rent. So the next whole bit that Karen's going to go through is just establishing that. It's making sure that this bit still only applies to rent, or it doesn't apply to any further cash payments.
Yeah.
Yeah.
Yeah, I get that.
Karen, do you want to?
No, that's okay, because the next couple are all linked into that. Clause 3, page 3, line 14, again, refers to making, so this is 5ZB, and it's again referring up to the rent, the payment of rent.
Yeah.
Yeah, and it's just showing that then receipts for other payments needs to say, so it was just putting the rent amount in because initially it was everything was to do with rent. Mm-hmm. Clause 3, page 4, line 19 is just the same thing. The both of them is just including the word rent for the controlled tenancies. Okay. Clause 3, page 4, line 25. As a consequence of including receipts for other payments. So, I don't know, David, as far as I can see, all three of those are all referring to the same thing. Are you happy with that?
The one that we wanted to draw attention to was the last one, wasn't it?
This was clarifying what offences the defence was. Is that what you were going to say?
Oh no, I was going to say clause the one in line 25 after landlord insert or former landlord, because again we're clarifying that this could be the former landlord of controlled tenancy.
Yeah.
Yeah.
Can't use this defence.
Yeah.
Okay.
And then the last one is just clause 3, page 4, line 25. And again, that's just inserting, extending the definition, making it clear that the cash payments are for tenancies, even if they've ended, or for former landlords and prospective.
Yeah.
Okay. Okay, so that's anybody else, any comments before move on to the second one of this?
No, just to commend you for your work, because you know you've there is great detail there,
Yeah.
but it's actually clear, and also the way you've presented it to us is very clear also, so thank you.
I suppose that's what we wanted to check, Claire. Sorry, Chair, that the what we've done matches what the committee wanted us to do.
Yeah.
In part.
We'll get to that.
This bit of it.
I think that's timely now. We'll move on. We'll look at the committee's proposed new clause 2A. At the meeting on the 16th of December, the committee further discussed the reasons why the department does not wish to consider taking forward the amendment proposed by the committee regarding placing a statutory duty on a landlord to offer a choice of payment options for rent and other payments related to the tenancy. In its closed session, the committee then considered the draft text of 2 potential amendments on this matter as drafted by the Assembly Bill Office. It discussed the second option as being too limiting. The committee agreed to share the text of the draft of the first option with the officials and OLC, and for Claire to liaise with them in advance of the meeting today in order to get a steer on any unintended consequences of the proposal. Members, we are waiting for our own legal advice on this matter also, and it will be received by the time we meet on the 11th of January. David, in your most recent response, you state that officials are exploring the proposed amendment urgently and will provide an update, if possible, at this meeting. Do you have an update on the department's view on the text of the proposed amendment?
We have been looking at this, and there's another meeting planned this afternoon to discuss it, but there's some things that, I mean, just in the interests of talking about it with each other as thoroughly and as quickly as possible, there's some things we'd want to talk about now,
Okay.
if that's okay.
Yes,
Yeah.
please.
So I suppose the first point we wanted to mention is that as it's drafted at the minute, it doesn't include an offence. It doesn't say what would happen if you didn't comply, what the sanction would be. As it's drafted at the minute, it doesn't say who would enforce it, the severity of it, or the, and also we thought, and as in how it's written, that there's possibly at least 2 offences being mentioned. There's an offence around not offering the choice, and the choice of 3 different payment methods, and then and on that one, would need to think about whether or not there's a continuing offence associated with that, and then there's one around not abiding by the method that's chosen, and then we were wondering whether or not that means that the tenant is bound to that as well. What happens if? I suppose at that point, what we want to do is think through how this would actually work. You would imagine a landlord and a tenant the landlord would offer 3 choices to the tenant. They would be in the tenancy agreement. So there's potential offence there if the landlord didn't offer 3 or offered so much more on the list, or didn't offer any choice at all. And then what would happen if the tenant, or what happened if they tried to change that afterwards, or regardless of what they had offered at the start, somewhere they changed it. And then what would happen if the tenant, from the tenant's point of view, if the tenant attempted to pay by one of the methods which wasn't on the list. So there's some things need thinking through there, and our experience would be those could be quite lengthy. I mean, just by way of example, you remember the changes to Schedule 2, where quite a lot of that relates to extensive drafting around continuing offences, and if you're having fixed penalty notices as well, or what different types of offences, different situations and things like that. So we need to think through all that, how it would work.
There were some issues as well, or some discussions that we had around the list of payment methods that was provided and the appropriateness of some of them, because although credit and debit cards were mentioned, credit cards, given the high interest rates that some of the credit card companies can charge, could actually put a tenant at risk of falling into arrears with their rent if they aren't able to make the credit card payments. And for some landlords, 83% of landlords own 1 or 2 properties, so it may not be possible, they may not have the technology available to them to accept the payment method in a prescribed format, which would effectively reduce the list and the options that were available by removing them, because they wouldn't have the technology to assist with those. For postal orders or for cheque payments, which are now largely they're not used so much nowadays. So there was some discussion amongst ourselves around well, what should be on the list, what could be on the list, and then I suppose a very fundamental point around, is this within competence of our bill, or are we starting to stray into an area that's outside the competence of the bill that therefore could subject the bill to some form of legal challenge as we move forward? So those sorts of discussions are also taking place.
So on the first one then, in terms of the methods of payment, there is a bit, and there's a provision in it which says that we can add or remove by negative resolution, which would be fairly straightforward. But I suppose we would need to try and work out, I mean, to what extent some of them overlap. So, and to what extent new electronic payment methods would be separate and would have to be listed on it, and or to what extent they're essentially some form of bank transfer. I mean, is PayPal and Apple Pay, are they a bank transfer, or do they need to go on it separately? And I mean, the answer to that at this sort of time scale is we just don't know. But we could conceivably end up with a very long list, which would mean that a landlord offering 3 could work their way around it by offering 2, which is almost impossible for the tenant to use or expensive for the tenant to use, and then cash, and then they actually would have done what they wanted to all along. Also, obviously, I mean, credit card is on it. Credit card is we're a bit uncomfortable about explicitly saying that tenants could use a method which puts them instantly into debt with a high interest rate on it. And some bank accounts don't offer checks anymore, and other ones offer them with fees. You have to pay a fee to use a check. But these are by way of just thinking through these things.
You need the other important one I thought was the need to get advice to consider where a landlord a tenant earn UC or housing benefit and the money's paid directly to the landlord. There's a whole issue around benefit payments and whether the tenant can choose, what way that's paid. Does it equate to a payment choice, and does it need to be included in the list? And what if it doesn't pay their full rent and top ups are needed? Would they have to pay 2 different ways? There's a whole lot of things around benefit clients that would need to be looked into as well.
Yeah. Eilish, well, there's an issue around commencement. We would need to consider when we would commence.
Yeah.
In drafting it. Then Eilish referred back to there was some discussion the last time about competence, and I know that the committee changed its approach, and our view on that would be that the new approach is more likely to fall within competence, but we're still considering that and to take a final position on that. There still isn't really any foundational policy work to base it on, which would help in this matter, and it still does have the potential to sort of vary, we think, to stray into some issues which are accepted, which are beyond me, and I've said that before. I know that you have sought your own advice on that, and that'll be available after Christmas.
Yeah. What we'll do, David, is we'll be speaking to Claire, as you know, after we spoke to yourselves here today, and we'll certainly discuss through the issues that you guys have raised. But you've said there's a meeting later on today. I think the same as previously. If that discussion between Claire and yourselves can continue, that would be very helpful. Paul, are you indicating?
Yeah. So I take it by commentary then you're not absolutely ruling this out. Notwithstanding the competency piece, which is a wider, bigger piece, which of course legal advice will have to be sought both by yourselves and of course we're doing it too, actively doing it too, and we'll have to just wait till that comes in. Can I ask if you were looking at the 2, and this is maybe putting you on the spot at an earlier point that you maybe wish, and if you don't want to answer it, that's fine. Looking at the 2 options, are you saying you'd be more content with the smaller, briefer option, or not because of what you talked about with regards to the list? I suppose that's the first question.
So the 2 options being
the first one being the 2 lines, basically offering choice. The tenant must be offered a choice.
Okay.
Or the more more descriptive one with the list then?
I mean, our initial view on competence would be that the list person would be more likely to fall within competence. Our questions then, as you've heard, are practical ones in terms of how would it work? What would this actually, on the ground, whenever two people choose to be landlord and tenant, what would happen? What do we want to happen? Are there any unintended consequences in there? How do you reflect that? And this is going to be primary legislation. And as we said, the most obvious one is you need to think through what offences you're creating and for who.
Yeah.
So those are sort of, suppose we gave the committee a commitment that we would look into this and see how you would do it and what it might look like.
The offences is a big one too, and I take that, and I think that has to evolve in our thinking. I get that 100%. The whole principle around this amendment, I believe, is that it offers protection. You know how I go on about 3B. So this to me is a way. This could be a way that offers the maximum protection as far as possible to legislate for it, that offers protection for both tenant and landlord. And again, with regards producing the list of payments, it doesn't have to be exhaustive, and of course there is that stipulation in paragraph 4 that allows the department by regulation to amend. And just because it's on the list doesn't mean it's a good option. So credit card wouldn't be a good option, cash wouldn't be a good option, but at least you're affording the choice. And we did discuss in committee the issue around, well, you could end up with a dishonest or a unprincipled landlord giving a Hobson's choice, whereby there wasn't much of a choice in the way you explain. And we would like to try and guard against that also the best way we can. I get the point about the offence, but it's for us at this stage, and it's very primitive thinking, it's all about protection and trying to prevent something happening. On the point you make, which is a very good one, around the part payments with regards to housing benefit, where housing executive would pay, that to me that's only ever one option, and that's giving a land, and I could be wrong, but it's paying the landlord through bank transfer, or if it's technically called a standing order, I don't know, but that's usually paid on a monthly basis. And of course landlords like that because it's regular payment. Now with that, it usually is the case that the tenant has to top up either £20 or £10 a week to make up the difference in rent. And then it would become, I believe this amendment would then become, it's that transaction between the tenant, purely the tenant, and the landlord. So whether it's £200 a week or £20 a week, part payment, it's that we're trying to protect and give choice. If that explains it with regards to the dual payment piece.
It does. I suppose for me, whenever we're looking at the amendment and we're looking at the original policy intent, what I'm trying to get my head around is the scale of the problem and the fact that we don't have any information. And I accept completely that what you're focused on a committee is offering the protection, to tenants who are making these cash payments. I completely understand it, but I suppose what I'm trying in our conversations with landlords, they want, as far as possible, to have the thing as seamless as possible and have the money paid into a bank account. And I've no doubt there are unscrupulous landlords who prefer a cash payment, but alternatively there are lots of tenants who want to pay in cash and who don't have bank accounts and don't really want to go down that particular route. So I suppose it's trying to think what's proportionate to the scale of the issue that we're trying to put an amendment in to resolve.
Yeah, so in my mind, it's very clear. It's just choice. And I agree with you. With those tenants that only have to top up a payment, £10, £20, £30 a week, or every fortnight, or whatever that regular payment is. In some cases, those tenants would want to pay in cash because it is only a tenner or a score,
Yeah.
and they can lift it off their purse or out of their wallet, rather than going through having to set up a bank account transaction. So I get that, but cash is still on offer. It's part of the choice, and it would really be for the tenant to choose what option they prefer, and the landlord should be quite accepting of that. So what we're doing is we're not trying to eradicate cash, but we're just making sure that there's the option there, and also that with payment in cash, there is protection there with regards to proof of payment.
And it's protecting the landlord too, because it's giving the landlord, the possibility of naming 3 options that then the tenant can choose from. But we need to be careful with that to make sure the Hobson's choice doesn't come into that.
And so you're clear, so you guys are clear, because I'll always be upfront and frank and honest with you. Notwithstanding the bigger argument and debate around competence, I really like this amendment. I really do.
Yeah.
Okay.
And for us, I suppose it's then to see how that, if it can be taken forward, not, as she said, notwithstanding that the competence question has been raised with us.
Yeah.
No, we'll certainly have a discussion about that. I know you guys are having a meeting about that later. If we just keep in contact about that, because we're getting close to the end of the committee stage, and it's going to be
Well,
fun.
I suppose we were quite aware of that as well, Chair.
Yeah.
It is getting to the point. You sort of thought quite a lot of those things that Eilish and I mentioned, with a bit of thought and the 2 parties working together, you might be able to find ways around. But we are getting short on time.
We are indeed.
Or is it? I don't know. I maybe shouldn't be speaking out loud. Sometimes my brain and my mouth don't coordinate at the same time. Is it an option to put an enabling power in to bring forward something like this if there's a lot of issue around competence, or does that not get around the competence issue? And so that's a conversation for us to have, David and Karen, later.
I know that's one of the ones that we'll need to think about as well.
Yeah.
Right, Eilish.
It might give us time to work through all those payment options.
Well, it just might, to give us more time, but still have an enabling power to say no. The choice has to be there. Meanwhile, the guidance could cover it off while that would be looked at. You should, as a tenant, you should make sure that your feelings are on your preferred method of payment are made known. But no doubt the power sits with the landlord at a point in time that the tenancy agreement is being signed.
Yeah. Okay. Yeah. Thirdly, then, members need to consider Paul's favourite, clause 353B. The committee further discussed this last week, and the response of the department to its letter dated the 10th of December and the reasons why the department does not wish to consider taking forward an amendment to remove 53B. The committee is yet to take a final decision on this matter. Members, we'll go into closed session after this part, but anybody have anything further to add on this today? We might even be able to come to a decision later on, but just at this stage, while officials are here, is there anything?
Chair, just other than say I'm still of the mind that it shouldn't be there. I understand why it's there, and I understand you're affording that reasonableness. I get that. I suppose I don't know if my poker face is on, but with the amendment now, the committee amendment, we're looking at and affording the choice and the protection for both tenant and landlord. That to me, that's more important probably than the actual 3B piece. So we'll see how that plays out, but I am certainly of the mind that at this present time, with things standing as they are, that 3B shouldn't really be there. That's not a final position, but it's the position at the present time.
And then I'm going to move on now to clause 7, restriction on rent increases. The time period in 5D4 be increased to 3 months. Last week the committee was pleased to note that the department is taking this amendment, and the text of the amendment is at page 12. Members, are you content with the amendment?
Yeah. Seeing that, I'm jumping about all over the
I know my papers are a mess at the minute.
This was the length of time,
Yeah.
the notice you have to give a tenant of an increase in rent. And we proposed, committee asked us to consider, and the department has agreed that it should be 3 months instead of 2.
Yeah.
So the amendment is take out 2 and put in 3.
Yeah, I was happy with that, yeah. Okay, then clause 9 and schedule 2, energy efficiency regulations. The committee did not take a position on this at the meeting on the 16th of December and requested a written breakdown of each amendment and what it does. This can be in the form of an updated EFM or a written briefing as soon as possible. David, I understand you guys are going to provide an updated EFM. Can you update when
Yes.
the committee might see this?
In the next day or 2, all being well.
Christmas present. Excellent.
Well, I suppose we want to get it done before Christmas, so we don't have to.
Brilliant. Looking forward to it. Clause 11, validity requirements for notices to quit given by landlords and tenants. Members, at the meeting on the 16th of December, the officials outlined the department's response that it wishes to reserve its position on any amended notice to quit period until the outcome of its recently launched consultation, which closes on the 25th of January 2022. Last week we discussed with the department the potential for our own amendment similar to Private Tenancies Coronavirus Modifications Act 2021, and in closed session we considered a draft amendment from the Bill Office. The committee has not yet taken a position on its possible amendment to clause 11, as we're waiting on our own the views of the Assembly Legal Services as to whether amendments of the type proposed by the committee would engage Article 1 of Protocol 1 of the ECHR and the potential consequences of this. Members, I propose we make a decision on that amendment on the 11th of January once we're in receipt of legal advice. Yep, thank you. Members, yesterday we received the report of the Examiner of Statutory Rules on the bill. This report is in your tabled papers at page 9. The bill contains a number of powers, each delegated to the Department for Communities, under which subordinate legislation may be made. The advice of the ESR is limited to consideration of whether the provisions of the bill inappropriately delegate legislative power and whether the exercise of legislative power provided for is subject to inappropriate degree of scrutiny by the Northern Ireland Assembly. The ESR is satisfied that these rule-making powers contained in the bill as presently drafted are not inappropriate and satisfied that in each case the exercise of these rule-making powers is subject to an appropriate level of scrutiny by the Assembly. Members, do you wish the ESR to come to a meeting on the 11th of January to go through her report? Yep.
Yeah,
Thank you. Members, in view of the fact that we have an amended Schedule 2 now, do you wish to request that the ESR provides us with an addendum advice on the new schedule?
Great.
Yep, thank you. Members, do you wish to receive the addendum advice run through her report and any subsequent addendum advice? Yeah. Yeah,
Great.
thank you. Members, just to highlight again that our committee stage ends on the 14th of January, so we'll make all final decisions at our meeting on the 11th of January. I'm sure David, Eilish and Karen will be looking forward to getting that finished. So we'll make all final decisions at our meeting on the 11th of January. We'll do the clause by clause and review the draft report as far as possible on that day. Members, any comments? Thank you. David, Eilish and Karen, at this stage, thank you so much. I know that there has been a lot of work put into this. We're going to go into closed session now with Claire from the Bill Office to discuss the bill and the draft recommendations paper. We might come back to you again, but we'll let you know as quickly as possible on that one. But thank you. At this moment, thank you so much.
Thank you, Chair.
Thank you very much.
Thank you. Bye.
So members, we are now going to move into closed session. Do we need to wait for the Assembly or for Starleaf people to let us know before I hit the button? Just to note before we go into closed session, I see Mark has joined us. I'm not too sure, Mark, when you come in, but we will make sure that you're recorded.
Here a while, don't worry.
Sorry, Mark.
Punch your card.
Are we okay to go into closed session? And members, we're into closed session and then we'll come back out again. Okay. Thank you, members. We're back into open session again. We'll just bring the officials back in again. So that's Eilish, Karen and David. Thank you so much, folks, for waiting for us. So a couple of things that we need to ask you about, and the first one that has come up is clarification with regards to the 2006 with respect to a fixed penalty. In 2006 clause 6 it talks about fixed penalties, but it doesn't confirm what that amount is. Now we imagine that a fixed penalty would have to be amended as time goes on, but we're just wondering what's the formula, or how is that set, or who sets the fixed penalty?
You were breaking up a bit there.
Oh, sorry, apologies. It's just in regards to the 2006, the committee were wondering about fixed penalties. What is a fixed penalty? It's not defined in the 2006 clause 6. It does talk about fixed penalties, but we're just wondering how the fixed penalty is calculated, who decides the fixed penalty amount?
The fixed penalty is a fraction. I'm sorry, I'm trying to find the 2006 order as I'm talking to you. The fixed penalty is a fraction of the tariff amount in the offence. So let's say in the offence, let's say either level 4 or level 3 or level 5 or something like that. And the fixed penalty is a certain fraction of that. And it can be paid to discharge the liability without it going to court.
Yeah,
So,
that's what we were just looking to see where that is in the 2006. If you guys
Sorry, Chair, we're flicking through the order here.
So the 2006, we thought it was clause 6 talks about the fixed penalty, but clause 6 doesn't go into it. It must be later in it somewhere.
It is.
there are fixed penalties in the order. I mean, I know we talked about bringing them in Schedule 2.
Yeah.
So is your question?
We're just wondering who sets the fixed penalty amount, so that must be defined in the legislation somewhere. Or is it?
I think it's something like a fifth of the fine or something, or?
My chair, from my memory, it's a fifth of it's 20% of the overall limit. So a level 5 is £5,000, so the fixed penalty will be £1,000.
But it would be set by the council. Is that not the case, that the amount of the fixed penalty notice is determined by the council, who are responsible for the enforcement of the private tenancies order?
So the process would be the council would spot that there's been a breach of the landlord's obligation. So they would enforce it with a fixed penalty notice. The landlord could then say, I don't agree with that, and they can go to court and take their chances. But on that instance, then you can be paid up to the full limit. So if it was a level 5, then the fixed penalty notice would be £1,000. But you would go to court and I suppose either argue your case and not pay anything, but you would be taking the risk that the court could fine you up to 5 times the fixed penalty notice.
Okay.
Karen, I'm looking at 62, the provision of directions and guidance to district councils, where it says the department may give directions of a general or specific nature or issue guidance as to the manner in which they are to discharge their functions under this order and the rent order. And then it says, without prejudice, the department may direct any...
68A is fixed penalty for certain offences. See if you look in 68A of the private tenancies order. So that's for tenancy deposit and landlord registration fees. The authorised officer may give pay a notice in the prescribed form. It's here, it says it somewhere as to how much it is.
Doesn't 68A doesn't actually specify a total though.
Does it not say something like a fifth or what does it say?
Can we check that out and give?
We'll
it's 68A. It's 1/5. It does set the fixed penalty payable to district council under this article in respect of an offence under Article 5B is determined by the council, being an amount not exceeding 1/5 of the maximum fine payable on summary conviction of that offence. And then, as you've seen going through, all of our offences have a tariff level in it, so level 4 or level 5. So then that sort of changes through time, but at the minute I think level 5 is £5,000 and level 4 is £4,000.
And tell me this.
So it relates to that.
in discussions with Solus, I think it's Solus, isn't it? You're talking to about the councils, you know, the registration moving over from yourselves to councils. Will there be a standardised approach guidance, you know, as it says there, you know, produced by the department to ensure that across Northern Ireland the councils would all treat offences in a similar way?
Because this is at sort of at early stages, and we're looking at a report that has been produced, we are working with the councils to look at what legislation would need to be in place, and that would include what the penalties would be for non-compliance with landlord registration scheme, and whatever that scheme will look like at the point of transfer. But yeah, that would be uniformity across all the council areas would be very important to make sure that whatever the new legislation is applied equally to all of the landlords.
Okay. Okay. Anybody else? Anything on that side of the fees? Sorry, as a committee, we were just looking for that clarification. The next one to come to is the committee are still attached to the committee amendment for 2A. But we are asking the question, would the department, would the minister provide an amendment for enabling power for 2A to sort of follow on from what the committee are looking for, that choice of payment method is provided for the landlord tenant? Would you guys be minded to bring forward an enabling power amendment?
We would have to. Well, we would have to discuss that with the OLC as to how straightforward it would be this afternoon, and then take the mind of the minister. I can see the attractions of it, to be honest, Chair. I think in our discussion earlier and in our discussion so far with our different types of advisors, I think the committee is suggesting to do something which might end up more complex than maybe you thought it would be whenever it was suggested last week. And considering the amount of time that to me sitting here now, there is an attraction to using an enabling power to give us more time to think it through.
Okay.
And to do it properly.
And a consultation, for instance, with that, yeah.
Yes.
Yes.
Okay.
Yep.
Yeah.
In the interim, then, is there a way that you can put it into the guidance, to the templates for a landlord?
Yeah.
Yes, absolutely. Yeah.
Okay, so the choice could be included in the interim into the guidance, and you guys will have a consideration then whether or not you'll provide an enabling power, you know, from the minister. We're still working on ours, so there's sort of two sides to this at the moment, so we're going to keep that going for a while, because we think that we need to have our own legal advice. As you know, we're still waiting on that, Paul. Yes.
Yeah, can I ask a question? If you were to go down the enabling clause route, what would be a reasonable time scale for you guys after all is sent?
We'd have to develop the policy around it and then carry out a consultation exercise. I hate saying this to you because I know you've asked us before around commencement, and we've been reluctant to commit to dates for the regulations to come forward, just because we want to make sure we do them properly and comprehensively. So I suppose I'm fudging that a bit by saying we'd want to do it properly and comprehensively.
Prepare for a consultation, do a consultation that will be 12 weeks, and then on the basis of that, try and construct something and then bring it in. So we need to decide in the enabling part if it was negative or affirmative resolution. So it would probably take about a year. My concern about committing too firmly to much is quite how much else we'll have going on in that same year, because we'll be taking the regulations for Schedule 2, the energy efficiency, the electrical safety,
Statement of tenancy terms.
Tenancy terms as well at the same time. So we would have plenty going on.
So 6 months is reasonable enough then? Leave it with us.
Oh dear, sorry, I'm laughing. You go nuclear, Paul. Yeah, so it would be very useful if you guys could come back to let us know if you would be considering bringing forward an enabling power amendment, because that could certainly help move things along. Anybody else have anything for the officials at this stage? We're getting close. We'll have to get close, guys, because the 14th of January we need to have this completed. I'm imagining we will see you again on the 11th to go through the amended EFM and any other tidy-ups that we need. But for now, I think I just wish you all a very Merry Christmas, and we're looking forward to
Thank
some
you.
Christmas afternoon reading from yourself with the amended EFM coming forward. But no, happy Christmas, and we will see
Same to
each
you.
other again next year. Thank you very
That's
much.
good. And same to you, Chair. All the best.
Thank you very much. See you next year.
Bye-bye.
Merry
Happy
Christmas. Merry Christmas.
Right, bye-bye.
Thank
Merry
you.
Christmas.
Bye.
Thank you. Okay, folks, we've left people with a bit of work to do now. Okay, so to be honest, unless there's anything else, we're on to agenda item 4, which is date, time and location of our next meeting. Our next meeting is next year, Tuesday the 11th of January at 9 a.m. in room 30. So we'll see you all there. And we'll need to make sure that everybody's in attendance, please, because we will be going through the final details and then clause by clause in advance of the 14th. But members, at this time, I'd like to thank you all for your hard work on the committee this year. It's been a particularly busy and challenging year. We know we're one of the committees with a higher number of legislation. Thanks to all of the Clergan staff. We've tortured you enough this year, so I hope you get a fantastic break. And to Claire McCanny, I don't know whether Claire will still be listening in if she's not lying in a dark room somewhere, but it has been very much appreciated. So all that's left is to say that I wish you all a very Merry Christmas, to all our witnesses, to our Clergan staff, to all of you, and a very peaceful new year. And we pass on our best wishes to our chair, Paula, and hope she's able to return to chairing our meetings in the new year. Thank you very much.
Thank you.
Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room.